She's ready to testify. Her lawyers have filed the lawsuit. Evidence has been gathered. Witnesses are prepared. There's just one problem. The man she's accusing? He's 3,500 miles away, behind palace walls, protected by centuries of royal privilege and international law. Prince Andrew, Duke of York, accused by not one, but two women of sexual abuse, facing fresh legal action in American courts. And yet, legal experts around the world are saying the same thing. He'll never testify. He'll never face an American courtroom. He'll never be held accountable. But why? In a world where we're told nobody is above the law, how can a prince simply refuse to participate in the justice system? What protections does he have that ordinary people don't? And what does this say about power, privilege, and justice in the 21st century? The answer will make you angry. It will make you question everything you thought you knew about equality under the law. Because when you're a prince, the rules are different. And the system is designed to keep it that way. January 2025. A second woman has come forward with allegations against Prince Andrew. Her lawyers are confident. They have testimony. They have evidence. They have a case. And they want Prince Andrew to answer for it. Under oath, in an American courtroom. The legal filing is straightforward. They're suing Prince Andrew for sexual abuse that allegedly occurred when she was a minor. Under New York's Adult Survivors Act and similar laws in other states, survivors have a window to bring civil cases even for abuse that occurred decades ago. The plaintiff's legal team has made their demands clear. They want Andrew to sit for a deposition. They want him to answer questions under oath. And if the case goes to trial, they want him in an American courtroom to face his accuser. This is about accountability, her attorney stated at a press conference. Prince Andrew settled one case, but he never had to answer questions under oath. He never had to look a survivor in the eye. He never had to face cross-examination. That needs to change. Legal experts immediately began explaining why this scenario, Andrew testifying in America, is virtually impossible. Not because he's innocent, not because the case is weak, but because of something far more fundamental. He's a member of the British royal family. And that status comes with protections that most people don't even know exist. Let me break down the legal fortress protecting Prince Andrew. It's not just one law or one loophole. It's a web of international treaties, diplomatic protocols, royal privileges, and jurisdictional complications that together create a nearly impenetrable shield. And understanding this system reveals something troubling about how justice works, or doesn't work, for the powerful. Here's a concept most people have never heard of: sovereign immunity. It's an ancient legal principle that says members of a royal family, particularly those in the line of succession, enjoy immunity from civil and criminal lawsuits. The idea comes from an old doctrine: the king can do no wrong. Literally, in traditional monarchies, the sovereign was considered above the law because they embodied the law itself. Now, Britain is a constitutional monarchy. The Queen, now king, doesn't have absolute power, but certain legal protections remain. Sovereign immunity doesn't mean members of the royal family can commit crimes without consequence, one international law professor explains. But it does create significant barriers to foreign courts exercising jurisdiction over them. Prince Andrew is no longer a working royal. He's been stripped of his military titles and royal patronages. But he's still ninth in line to the British throne. He's still the king's brother. And that blood connection matters in international law. Even if we set aside sovereign immunity, there's a massive jurisdictional problem. The alleged abuse occurred in London, British territory, not American soil. Prince Andrew is a British citizen residing in Britain. American courts have limited power to compel testimony from foreign nationals living abroad, especially for acts that occurred in their home country. Yes, American courts can issue subpoenas and court orders, but enforcing them? That requires cooperation from British authorities. And that's where things get complicated. The United States and the United Kingdom have a special relationship: diplomatic, military, intelligence sharing agreements that make them closest allies. Both governments are extremely careful about doing anything that might damage that relationship. Forcing a member of the British royal family to testify in an American court would be seen as a diplomatic affront, a violation of British sovereignty, an international incident. Behind the scenes, diplomatic channels would activate. The British government would likely file formal objections. The U.S. State Department would get involved, weighing the legal case of one survivor against the broader strategic alliance with Britain. And in that calculation, unfortunately, the individual survivor almost always loses. Here's the blunt reality. Prince Andrew can simply refuse to travel to the United States. He's not under arrest. There's no criminal warrant. He can't be extradited for a civil lawsuit. And British authorities have no obligation to force him to go. Andrew hasn't traveled to the United States since the allegations became public. He stayed firmly on British soil, where American courts have no direct enforcement power. And as long as he stays there, he's effectively untouchable. We've seen this exact playbook before. Because this isn't the first time Prince Andrew has faced American legal action. In August 2021, Virginia Giuffre filed a civil lawsuit against Prince Andrew in U.S. federal court. The allegations were detailed and disturbing. The evidence included the infamous photograph. The case attracted global attention. Andrew's legal strategy? Avoid, delay, and settle. First, his lawyers tried to get the case dismissed on jurisdictional grounds, arguing that as a British royal, he couldn't be sued in American courts for conduct that allegedly occurred outside the U.S. The judge rejected that argument, ruling that American courts do have jurisdiction over civil claims of sexual abuse, regardless of where they occurred, if the defendant has sufficient connections to the forum. Then came the question of serving Andrew with legal papers. For months, his legal team played games, arguing over whether he'd been properly served. They used every technical delay tactic available. Andrew never traveled to the U.S., never sat for a deposition, never answered questions under oath. Finally, in February 2022, just weeks before he would have been compelled to give a deposition, Andrew settled. The reported amount, £12 million, plus a donation to Virginia's charity. The settlement came with no admission of guilt, no acknowledgement of wrongdoing, just money to make the problem go away. And crucially, by settling, Andrew avoided the one thing that terrified him most, having to testify under oath. The settlement was strategic, legal analysts noted. Once you sit for a deposition under oath, that testimony becomes permanent record. It can be used in other cases. It can contradict your public statements. Andrew's legal team understood that testifying was the most dangerous thing he could do. It's a strategy that only works if you have unlimited resources, elite legal counsel, and the protection of staying in a country that won't extradite you for civil matters. In other words, it's a strategy available only to the ultra-wealthy and ultra-powerful. So what can American courts actually do if Prince Andrew simply refuses to participate? If Andrew doesn't appear and doesn't defend himself, the court can issue a default judgment, essentially ruling in favor of the plaintiff because the defendant failed to respond. But here's the problem. A default judgment is just a piece of paper. It awards damages, but collecting those damages from someone living in another country is nearly impossible. American courts can try to seize Andrew's assets in the United States, but he's already stopped traveling there and likely has no significant American assets in his name. Any property or investments would be held through trusts, shell companies, or royal entities that are shielded from seizure. The royal family's wealth is structured in ways that make it extremely difficult to access. The Duchy of York properties, Andrew's official residence at Royal Lodge, his inheritance from the Queen, none of these are easily seized by foreign courts. The US and UK have mutual legal assistance treaties, MLATs, that allow them to request help with legal proceedings. In theory, US prosecutors could ask British authorities to compel Andrew's testimony. But MLATs are typically used for criminal cases, not civil lawsuits. And they require both governments to agree the request is legitimate and important. Would the British government force a prince, the king's brother, to testify in an American civil case about sexual abuse allegations? Legal experts say, absolutely not. It would be political suicide. It would be seen as capitulating to foreign pressure. It would infuriate monarchists and traditionalists. The only scenario where Andrew could potentially be compelled to face American justice is if U.S. prosecutors brought criminal charges. Unlike civil cases, criminal charges can trigger extradition treaties. If Andrew were indicted for sex trafficking or related federal crimes, the U.S. could formally request his extradition from the U.K. But even then, it's not automatic. The UK-US extradition treaty has exceptions and political considerations. The British government could refuse extradition on public policy grounds or if they believe the request was politically motivated. And here's the reality. U.S. federal prosecutors have shown no indication they're pursuing criminal charges against Andrew. The evidence bar for criminal prosecution is much higher than for civil cases, and the diplomatic complications would be enormous. Unless there's overwhelming evidence of criminal conduct and political will at the highest levels of the U.S. government, one former federal prosecutor explained, it's just not going to happen. So here's where we are. A woman says she was sexually abused as a teenager by Prince Andrew. She's willing to testify. She's willing to face cross-examination. She's willing to face public scrutiny and harassment. But the man she's accusing? He can simply stay home and ignore the entire legal process. When news broke that Andrew would likely never testify, public reaction was swift and furious. This is exactly why people are losing faith in the justice system, one legal reform advocate said at a press conference. We're told everyone is equal under the law. But that's a lie. If you're rich enough, connected enough, royal enough, you can buy your way out of accountability. Social media erupted with anger. Hashtag royal impunity trended alongside hashtag justice for survivors. Thousands of people shared their own stories of being failed by a legal system that protects the powerful. Wealthy executives accused of fraud flee to countries without extradition treaties. Politicians accused of corruption enjoy immunity while in office. Celebrities accused of assault settle lawsuits with NDAs that silence victims. The super-rich use offshore accounts, complex corporate structures, and elite lawyers to stay beyond the reach of normal legal processes. Every time a powerful person escapes accountability, it sends a message to survivors, a trauma counselor specializing in sexual abuse cases explained. It tells them, your pain doesn't matter. Your truth doesn't matter. The system isn't designed to protect you. It's designed to protect them. Meanwhile, Prince Andrew continues living at Royal Lodge, his 30-room mansion in Windsor. He's been seen horseback riding, attending family events, and living comfortably despite being effectively exiled from public royal duties. He'll never wear his military uniforms again. He'll never represent the crown at official events. But he'll also likely never face the inside of an American courtroom. The woman suing him continues her fight. Her lawyers say they'll pursue every legal avenue available. They'll seek default judgment. They'll try to seize any accessible assets. They'll keep the case in the public eye. But privately, even they admit, getting Andrew to actually testify is virtually impossible. So why is it unlikely, virtually impossible, that Prince Andrew will ever testify in the United States? Because the system is designed to protect people like him. Sovereign immunity, jurisdictional limitations, diplomatic considerations, international law complexities, unlimited legal resources, and the simple ability to stay in a country where foreign courts can't touch him. These protections weren't created specifically for Prince Andrew. They're built into the international legal system, a system created largely by and for the powerful. For an ordinary person accused of the same things, none of these protections would exist. They'd be compelled to appear, face their accuser, answer under oath, or face immediate legal consequences, arrest, default judgment, asset seizure. But Andrew isn't ordinary. He's a prince, and that makes all the difference. The woman pursuing this case knows the odds. She knows Andrew will likely never answer her questions face to face. She knows he'll hide behind lawyers, settlements, and palace walls. But she's fighting anyway, because sometimes speaking truth is more important than winning. Sometimes refusing to stay silent is the victory.